Welcome, everybody. My name is Michael Cahill. I'm the dean here at Brooklyn Law School, and I am delighted that we are able to organize this event to have you all here today. I am just going to very briefly say thank you to our event staff, and particularly Liz Alper, who you might not be able to see directly, but her imprint is all over this event, and the fact that it is running smoothly is due to the efforts of her and our IT staff, and many thanks to both of them. It's particularly enjoyable and rewarding to have events of this kind because they really emphasize a couple of the strengths of Brooklyn Law School. Really, as a faculty and as in terms of where our graduates go, we have a lot of strength in terms of law that is designed to address or prevent wrongdoing, and particularly criminal wrongdoing, as exemplified in part by our Center for Criminal Justice and the number of graduates that we have who work in criminal law enforcement or in criminal defense. And of course, corporate governance and corporate regulation, as exemplified by our Center for the Study of Business Law, which is sponsoring this very event. So very happy to have an interest in the public law of enforcement as well as the private law of corporate governance. Those two things come together in the case of an event like this one, and of course they particularly come together in the embodiment of a couple of people involved in this event. So for example, our own graduate, Winston Paez, from whom you will be hearing soon, is someone who I will take credit for as an exemplar of our ability to train people with regard to criminal law and corporate law. And of course, Miriam Baer, who is organizing this event, is the embodiment of our faculty expertise in both criminal law and corporate law. So exactly the right person to be hosting and organizing an event of this kind. And I take Brooklyn Law School to be exactly the right place to be hosting an event of this kind, even if at a distance. So very pleased that it brings you all here today. And very pleased that we have a person like Miriam here to organize and oversee such events. So without further ado, thanks to Miriam, and I will turn it over to her.
Great. Well, thank you so much, Dean Cahill, for that wonderful introduction. Good afternoon to all of you as you're coming in. My name is Miriam Baer, and I'm a professor here at Brooklyn Law School, where I teach and write about subjects related to, as Dean Cahill alluded, corporate and white-collar crime. And I, too, would like to thank the fabulous IT and events folks who have helped us put this program on today. This program, which is sponsored by Brooklyn Center for the Study of Business Law and Regulation, is devoted today to the topic of corporate whistleblowing. Now, whistleblowing, both the practice itself, as well as the legal infrastructure that has arisen to encourage its growth and implementation, has become one of the major tools regulatory agencies, such as, for example, the SEC and the CFTC, rely upon to enforce a wide array of statutes and regulations. And it is driven by two distinct but prevalent forces. The first one, which many of you likely recognize, is one of information-driven need. Organizations, particularly for-profit corporations, can be incredibly opaque. By design, responsibilities are split among different units, departments, or divisions according to various folks' competencies. Right? And so a typical corporation operates according to whatever its internal firm hierarchy may be, and it's governed by some combination of either state corporation law and whatever additional regulations apply to it, depending on, for example, if it's a publicly held company, and also the particular industry it operates in. Now, as the company's many units develop their own way of doing things, they become generators and keepers of information. Now, theoretically, the firm's highest authority, the board of directors, aided by top management, should be responsible for amalgamating these disparate pieces of information and disclosing material information to the company's shareholders. But even under the best circumstances, we know that information silos can form. One group doesn't want to tell the other group everything that's going on. And is in these sort of black holes or vacuums that wrongdoing can particularly fester and grow, often unseen and even untouched by many within the company, and certainly unseen by many outside the company. And so from this perspective, whistleblowing plays very much the same role as many of the other types of tools we've become used to seeing, like, for example, civil liability or audits, or any of the other types of tools we rely upon to extract information from the company, right? And in that sense, what it's doing is help us confront what could be an information bottleneck. In other words, you can think of the corporation as a bottle and information needs to get out. And so whistleblowing can be a tool to procure that information more promptly and more efficiently so that the government might redress and prevent wrongdoing, and to do so more effectively and quickly than might otherwise have been the case. Now, the second explanation for whistleblowing is in some ways more amorphous, but just as important, and that is there's a desire to create a constructive outlet for those members of an organization who are witnesses to wrongdoing, who recognize and understand the moral and economic harms embedded in such wrongdoing, but who lack the ability, fortitude, or even the simple know-how to recognize and respond to such misconduct. And this is even more true when an employee witness who occupies a subordinate position within the firm. We all like to imagine ourselves as heroes. But when the boss tells the employee to file some sort of false form, to lie to an auditor, to inflate revenues, to create fake accounts, to cover up some meeting with a foreign official, the mind's capacity to rationalize such behavior and avoid confrontation, we know from all sorts of literature, comes into play. So whistleblowing isn't simply a regulator's handy enforcement tool. It's also a practice that can build moral fortitude, and it can be a practice that changes our internal preferences and the cost-benefit analyses we play within our heads when we see something that's wrong. And as the practice becomes more salient, it reminds employees of their moral responsibilities to protect the firm from internal wrongdoers. Moreover, when it's publicized and well known, it can serve as a very useful coordination device. It provides the good citizen employee with a viable outlet and a path out of what could look like an otherwise intractable puzzle. And it matches them with a regulatory enforcement office whose members have been charged with analyzing and responding to whistleblowing complaints. In other words, if you set up the right kind of program, the idea is you're going to match the employee with information to the regulator most inclined to listen to it. So that's the theory. How we implement these programs to most efficiently break information bottlenecks and maximize the whistleblowing program's coordination function is easier said than done. And as a practical matter, we know that whistleblowing infrastructure in the United States has sort of developed into two major prongs. There's an anti-retaliation prong, which is, I think many recognize it as an imperfect feature of legal programs. It's supposed to protect whistleblowers who reveal information from being retaliated against, and we'll hear some about that today. The second, and perhaps more celebrated and more recent prong, is the manner by which the government agencies, at least in the United States, have begun to financially reward whistleblowers for original information that leads to recoveries that exceed some threshold, usually at least $1 million. How the government goes about creating and implementing these two components, the anti-retaliation prong and the bounty program, can play a big role in the volume and quality of information the government receives. Moreover, how the government defines even whistleblower status, what counts as a whistleblower and what doesn't, plays an even more important role in when employees blow the whistle and which government actors they're going to actually approach. And finally, the more complex and sophisticated these programs grow, the more the actors on both sides, both the putative whistleblowers and frankly the regulators themselves, will become dependent on the expertise of intermediaries, namely the law firms who have come to actually represent whistleblowers. Today's speakers are going to explore different aspects of everything I've just given you in this overview. They'll talk about whistleblowing law and whistleblowing policy. And they will discuss, among other things, the SEC's bounty program, recent changes that were either made in that program or that the SEC at least considered, as well as whistleblowing's behavioral components, its interaction with what we call the corporate compliance function, its effect on corporate defense attorneys and prosecutors alike, and lessons we might glean from comparisons between our experience and the experience, for example, with the EU. After our panelists have had a chance to offer their distinct insights, I'm going to moderate a discussion among them, and then I will eventually invite you, our audience, to ask questions of your own with the fancy little Q&A button you probably see there on the bottom of your screen. You can hold off writing anything in the Q&A for now, but we hope that we can encourage you later to put your comments in there. Now, before we move on, let me say a few words about our four panelists who are fantastic. Mary Inman is a partner at the law firm of Constantine Cannon. She's based in San Francisco and London, and she's the head of her firm's international whistleblowing practice. She will talk today about the SEC's newest rules on whistleblowing and also give us her perspective on some of the pitfalls and challenges of actually representing whistleblowers. On the other side of the practitioner column, we have with us, you may have already heard my dean referring to this, Winston Pace, who is a BLS alum from the class of 2003, and not so long ago was the chief of the Business and Securities Fraud section for the U.S. Attorney's Office here in the Eastern District of New York. He's now a partner at Debevoise & Plimpton, representing corporate and individual defendants, and he will provide his unique perspective as both a former government attorney, a prosecutor, and now as a defense attorney. We also have two tremendously gifted scholars with us today. Dr. Katja Langenbucker, who is a visiting professor at Fordham Law School and a professor at Goethe University's House of Finance in Frankfurt, and also affiliated with Columbia Sciences Poe program, has written extensively on and studied both the behavioral and regulatory aspects of whistleblowing, and she's going to provide us today with comparative insights when she discusses the EU's experience with whistleblowing. And finally, we also have with us, and we're very lucky to have with us, Professor Jennifer Pachella from Indiana University's Kelley School of Business, where she teaches topics related to business law and ethics, among other things. And she has compared the treatment of whistleblowers under a number of schemes, including, for example, the Dodd-Frank Act and the Internal Revenue Code. She has recently co-authored a piece forthcoming in the Georgia Law Review that examines the interaction of whistleblowing and the corporate compliance function. And she has warned of gaps in the legal protection for employees who attempt to adhere to their employer's internal compliance policies, but find themselves on the receiving end of retaliatory efforts or worse. Together, this group is going to help us think about the practice of whistleblowing, how it functions, and how it's likely to grow in the future as both a practice and a regulatory subject. Before we proceed, let me just offer a little bit more. So we're going to hear from each speaker. As I said, then I'll convene some conversation among the speakers. And then at that point, at some point, I will turn it over to the audience and I'll say something. I'll invite you to put your questions in the Q&A. Hold off on those questions for now. I promise you will have the chance to put those in. Now, with that, I'm going to turn it over to Mary Inman. Mary, why don't you start us off?
Really excited to be on this panel today with this esteemed group. So what I want to talk about in terms of my personal experience, as Miriam mentioned, I head my firm's international whistleblower practice, but I have worked for the past 23 years specializing in representing whistleblowers, primarily under the U.S. Whistleblower Reward Program. But what the vantage point I want to bring to today's discussion is, as someone who's long in the tooth in this area, when I started out 23 years ago, the only whistleblower program that existed was the Department of Justice False Claims Act. And since that, and basically because of the enormous success of that program, if you talk to folks in the DOJ and U.S. attorneys' offices, they will say that whistleblowers are their number one enforcement tool, which makes a lot of sense when you think that whistleblowers are insiders. They basically can bring information that provides former prosecutors like Winston sort of a roadmap to the fraud. So the data that's sort of particularly interesting about the DOJ program, we have since 1986, we know that the Department of Justice has recovered $62 billion between 86 and 2019 as a result of whistleblower-initiated access, whistleblower-initiated cases. The whistleblowers themselves have received over $7.4 billion for bringing this information forward, which represents 16% of the proceeds that they've helped the government recover, which I would say is a nice return. that they're able to help the government. So it's because of the success of that program that it encouraged programs like the SEC to say, hey, we should start using the whistleblower tool as well. So the IRS was the first to get on board with their IRS whistleblower program. Then came the SEC, CFTC, and now little-known programs, but ones that I operate under, is the Department of Transportation. In the wake of the Takata airbag scandal, has adopted its own program. We, in fact, represent two of the Takata airbag whistleblowers who brought that information forward about. So under that program, if you're a supplier or parts supplier anywhere around the world, and you have information about safety defects, you can bring that to the DOT, sort of with the inspiration of hoping to stop some of the 26 fatalities that happened as a result of the Takata airbag sooner. The other big development is that the department, the FAA, as a result of the Boeing scandal, is considering a whistleblower reward program similar to the DOT. And in addition, as a result of the FinCEN files, leaks, there is a money laundering whistleblower program being considered. So I say all that by way of saying success breeds success. And certainly in the United States, it's been an exponential growth in whistleblower programs, which has certainly helped to keep me and my office busy. The other point I wanted to make is that the evolution of the U.S. whistleblower programs has been really stark in that it started with insiders, which is what the False Claims Act seeks to encourage insider whistleblowers to come forward. But we've seen the evolution from an acceptance of traditional insider whistleblowers to the evolution of what we call whistleblower outsiders looking in. So that's been a really fun development in my practice. The SEC program in particular was modeled on a whistleblower outsider by the name of Harry Markopoulos. He was not an insider at the Madoff in Madoff's organization. Instead, he was just the financial services advisor who used his statistical knowledge to say it's impossible to get the returns that Madoff was promising, and he brought that information to the SEC. So we're definitely seeing more in the way of competitors bringing whistleblower cases against their competition, experts who take publicly available data and bring that to the various programs as well. So it's an exciting time to be a whistleblower, and I feel like the bet that I made 23 years ago that this would be a good area has certainly borne fruit. You had asked us to talk a little bit about recent developments. I'm happy to talk later with you about what the SEC has done. The SEC program shares similarly compelling data to the False Claims Act in terms of most recently, since the program first came online about 10 years ago, over $2 billion in fines have been imposed by the SEC as a result of information tips provided to them by whistleblowers. Those whistleblowers, as of June 23rd, had received over $501 million to a total of 85 whistleblowers. So, again, a very important and successful program. So there's been some changes to that. I'm happy to talk about that later with you, Miriam, because there's always a question of why mess with success. That's a very successful program. Some of the changes I think are helpful and some I think are harmful. And of course, I think that's pretty much just a good overview. I'm happy to talk about, of course, the boom that has been happening for all of us, which is the COVID-19 with the billions of dollars from the CARES Act and the Paycheck Protection Program. It's another area that is ripe for whistleblowers to help police the misappropriation of these funds, because as we all know, that money came out fast and furious with very little oversight. So that's been another area where we've been working very closely with whistleblowers, not just for the American funds, but in fact also in the IMF. Part of that is also funded by American dollars, so whistleblowers can help in that respect as well. So COVID has presented very busy times for us as well.
Thank you, Mary, and we will take you up on that and ask you additional questions. So Mary gave us that overview of what the sort of history of where these programs came from. Jennifer, I'd like to now turn to you because you've now written a lot about sort of the experience of the corporate employee and how these things all come together. So I'll now turn it over to Jennifer Pachella.
Thank you so much. So first, thanks so much, Miriam, for the invitation to take part today in this great panel. It's great to be here, and thanks everybody for taking part. So yeah, I was going to kind of touch upon two distinct areas of kind of latest developments in whistleblowing, one of which has to do with COVID-19, because I think there's so much happening in the field of whistleblowing that stemmed from the pandemic that really kind of opens our eyes a lot to the important difference. I think this is just a fundamental point for any whistleblowing discussion of the difference between the internal whistleblower who reports on the inside of their organization to, boss, superiors, colleagues, whatever it may be, versus the external whistleblower who's going outside of the organization. Right now through the pandemic, very interesting times where we're largely away from our workplace cultures, we're away from office politics, we're away from sort of all the power dynamics that typically could exist. And in my view, this has really largely eliminated the fear of retaliation that would heavily go on for most people deciding to become internal whistleblowers. And so this actually has been confirmed by the SEC recently, which has reported a record increase in whistleblowing tips from mid-March to mid-May of this year. That's a 35% increase compared to that same time a year ago, and has also processed many more bounty claims than that time last year. So I think it's a time of actually high whistleblowing. There's a lot of workplace, there's minimal workplace accountability. Misconduct is a little bit high right now. Lots of organizations are suffering financially, and then going down kind of what you were mentioning, Miriam, of rationalization process of no excuse for wrongdoing, but it's happening, right? And so one important point I want to make is that I think this has very important effects on dramatically increasing external whistleblowing, right? Which is the kind that's most disadvantageous for organizations, right? Because it leads to, of course, things like litigation, publicity, no opportunity to fix a problem in earlier stages that an internal whistleblower would bring. And so this dynamic of internal whistleblowing, at least during this period, seems to be fading. There's really no opportunity to talk face-to-face with people. I mean, we can talk on Zoom, but we all know that's really different than kind of reading somebody's body language and feeling out a response to your boss on very sensitive or potentially damaging information. And also, I think for many people, if I can venture to say, I'm not sure that the workplace is on everyone's top priority list right now, right? Especially with working parents. You've got kids with daycare centers closed, schools closed, homeschooling. So it's, I think, a little bit of kind of an out of sight, out of mind situation happening that could really ramp up whistleblowing on an external level. And so this is problematic for organizations. It's also problematic for the whistleblower, him or herself, right? Because as I'm going to talk about a little bit later more too, internal whistleblowing now, at least from the corporate whistleblowing standpoint, we've seen is really not as protected from retaliation as we would have expected. And a lot of that is due to a very monumental Supreme Court decision in 2018, Digital Realty versus Summers, which had resolved a very long-standing circuit split and really has now come out and made firm that in order to be protected from retaliation as a whistleblower under the Dodd-Frank Act, you would have had to definitely have blown the whistle directly to the SEC and then faced retaliation because of that. So an internal whistleblower who's reporting internally, right, to colleagues and bosses, and then is retaliated against would be barred from any retaliation protections under that statute. And so I think many of us probably view that as a big disadvantage for whistleblowers, just given the language of the way that Dodd-Frank was written. And so it's a time, I think, that it's important to, especially from an employer standpoint, kind of check in with people, make sure that everybody's aware of internal reporting systems that occur, hotlines or other channels. Just asking your employees how they're doing, right, things like that, and offering kind of support outlets so that we can all remember we're, part of an organization, so that whistleblowers can, as most do, opt to report internally, right? And then the other kind of big development that maybe Mary's going to speak about too, so I hope I'm not stepping on toes with this at all, but yeah, it's another big development just from the world of the corporate whistleblower, because the SEC had just voted in September to adopt amendments to the rules that interpret the Dodd-Frank Act. It's published guidance on determining bounty rewards now. And so it's made several, notable changes for that, one of which is it's providing a mechanism for any whistleblower with a potential award of less than $5 million, which that's historically comprised about 75% of all whistleblowing awards, is now going to qualify for a presumption that they'll actually receive the maximum statutory amount. And so the hope there is that that will increase efficiency, in determining kind of at what end of the spectrum whistleblowers fall. I'm curious to hear others' opinions on whether we think that will in fact increase efficiency or not. Another notable development with this is that the SEC has now made clear that whistleblowers whose information leads to something like a settlement agreement, a deferred prosecution agreement, a non-prosecution agreement, even though all of those are outside the realm of a judicial or administrative proceeding, they now will all count as sort of what the SEC would define as resulting in an award for the whistleblower. And so I think that's a notable development, because so many of these sort of non-judicial, non-administrative mechanisms are used so broadly. And this will allow more whistleblowers to, in fact, obtain, a reward in this context. And also, one other thing is that the SEC has had to conform the definition of whistleblower to adhere to that Supreme Court case I mentioned, that it's certainly somebody who is reporting to the SEC directly, in writing, in fact. And it would only be if they're retaliated against for that report will they then be protected from retaliation through that statute. So that's now been, eliminated. All past interpretations that the SEC was, kind of pro-internal whistleblower, had a view of that for Dodd-Frank. It's just not the case in the law. There's still many ways to encourage it, and I think the agency does, encourage it, but it's now been confirmed by law. And the last point I'll just make is that it's also interesting with these amendments that there are mechanisms to prevent anyone who's submitting materially false or fictitious information, which is not the majority of whistleblowers usually. Most are absolutely the most loyal employees, truly care about the entity, but you sometimes do get people submitting claims with no merit. And so the SEC is now going to permanently bar anyone from receiving a bounty reward if they've abused that process 3 times. And there will be a warning procedure in place so that they will have a chance to withdraw applications, if they're falling into that boat. So I think those are all just really interesting developments that pertain to all corporate whistleblowers in the SEC context. And then it's interesting to just kind of think comparatively about how these all various federal whistleblowing statutes compare and contrast. There are a lot of differences between them in terms of remedies and protections. And I think we're all still waiting for that one overarching federal law that's going to just protect all whistleblowers that we don't have yet. So yeah, I will stop there and turn it over to the next person.
Right. So thank you so much for that sort of overview, I think, sort of the experience of the employee, and also of sort of some of the changes that are sort of developing. And also, just to highlight, it is an amazing thing that if you report something externally to an agency other than the SEC, and then your employer retaliates against you, you do not get protected under Dodd-Frank. But if you talk to the SEC in writing, you do get protected theoretically, you could be protected under the anti-retaliation laws. And I think that's something that we can take up later on, but it's just something that I think probably an outsider to the United States might say, wow, Congress really intended to do that? That's strange. And so with that thought of the hope of learning from folks in other countries with expertise, with other programs that perhaps work better, or maybe just have learned lessons that we can apply, I want to turn it over to Professor Langenbucher, who can talk to us, among other things, about the EU. Katja, take it away.
Well, thank you so much, Miriam, for having me. And
I'm afraid there won't be much for you to learn from me, and rather it's going to be the European Union who's going to learn from the US. So I have a quick presentation for you just to let you know where we're coming from. And so you see that there's really not much going on in terms of whistleblowing protection in most countries of the EU. There's 10 out of 28 which have a meaningful whistleblowing program at all, and there's no retaliation except for 8 member states. There's only 3 which still don't protect the identity of the whistleblower, et cetera, et cetera. So, and I'd be happy later on to talk maybe about the cultural differences, because imagine or remember that we have a fascist and a communist history behind us, and so whistleblowing in Europe is seen really different than it is in the United States, which might account for the fact that we don't have really meaningful and good whistleblowing regimes so far. So there were a couple of first steps at EU level. We have an antitrust whistleblowing program which works well with the leniency policy and an anonymous whistleblowing tool, and there's also the OLAF, the Anti-Fraud Office, which has an anonymous tool. But apart from that, the 2019 Whistleblower Regulation is sort of the next step. And the first step, really the first meaningful step in the European Union. Because it's a regulation, it means that it's not going to be the same regime in every member state, but the member states of the European Union get discretion in how they transpose it into their laws of their respective countries. Now, a really quick overview, just to give you an example of what it's probably going to look like. So as you see, there's 10 key areas of European Union law, and violation of these areas of the law are going to qualify only for whistleblower protection. Most interesting is probably finance, procurement, and maybe also consumer protection and privacy. The personal scope of the whistleblower, so who is a whistleblower, is pretty broad. It's, of course, a worker, so the internal ones, but it's also self-employed. It's people on a supervisory body. It's volunteers, trainees, contractors. It's pretty much everyone. The idea, which is not as clear as I would have hoped to, is you're supposed to start reporting through internal channels. That's what the regulation tells you to. But then at the same time, they also say, well, you can also report through external channels. And it's not really made clear whether you have the free choice. What the 33 thing here is from the beginning of the regulation, which is in European law, and it usually starts out with a couple of what we call recitals, explaining to you what the whole law is about. And so in these recitals, they say, well, usually people prefer reporting internally. So I don't know whether that is true for the US experience. And so the European Union says, well, empirical studies show that, so this is what we would like them to do. But if there's a reason for them not to report internally, then they can also do it externally. Oh, well. The last step, and what the regulator clearly doesn't like, is public disclosure, obviously, right? So they say public disclosure, you only qualify for protection under the regulation in pretty, couple of smaller cases. Namely, you see down there on the slide, there's a danger to the public interest, or there's a manifest risk of retaliation and a low prospect of the issue really being effectively addressed. So stepping out and kind of before anything else publicly disclosing the problem is nothing the European regulator likes very much. Now, what the regulation also does, because as I said in the beginning, a lot of countries don't have that yet, they require you to have an institutional structure. So a private and a public entity have to establish special internal reporting channels. We do have that for regulated industries right now, but not for all the rest, so to speak. So this is something which has to be established now. And also we need to have in each member state a public whistleblower authority. That could be part of like a financial authority such as the SEC, but it could also be a special kind of whistleblower agency, as I say, that the member states have discretion. Now, what's the protection offered? It's confidentiality of the identity.
better than nothing. Prohibition of retaliation, sort of the same as in the US. There's generally, with a number of exceptions, no liability for whistleblowers as to how they acquired the information they're blowing the whistle on. And there's a whistleblower burden of proof for whistleblowers for their own liability claims. Now, I talked about the cultural concerns already, and I'm happy to talk about that further. There's nothing about financial rewards in the regulation, which is something which I'm unhappy about because I like looking to the SEC. And there's also no duty to follow up on anonymous whistleblowers. This is left to the member states. I don't know if some of you have heard about the McDonald's case, which had been tried in France. And the French are extremely reluctant about it, and that's what what the court said. Whistleblowing is an organized system of denouncement. We don't like that, and just take that in against the background of what I said about culture. And last slide also, what might be of interest possibly for a United States audience is thinking about data protection. Because it's already for the European Union not really clear how to bring data protection and whistleblowing together, both for the internal whistleblower, the corporation which gets the information has to protect both the whistleblower and the other people on which the whistle is blown, so to speak. So collecting and processing information is complicated. And also, you might have heard about the recent ECJ decision, the Facebook decision on the General Data Protection Regulation in Europe. So it might be really tricky if you're transferring information outside of the US under these contractual duties we had so far, and which the European Court of Justice is now pretty skeptical about. So it's a challenge for, I guess, US corporations to comply with both Sarbanes-Oxley and the GDPR. So far about, a quick run through the European framework. As I say, I hope to learn more than you will probably be able to learn from me, but I'm looking forward to the discussion.
Right, so thank you so much. I do have one clarifying question just before we go forward. So when you say public disclosure is disfavored, in that case, the public disclosure means what? Talking to a journalist? Going
right.
on? Yeah, that. Okay, so
yeah,
that's not
that type of public, yeah.
Right, that's the kind of thing. So that is, we will definitely talk about culture. So as Dr. Langenbrooker's presentation demonstrated at the end, it's always an issue for the corporation to sort of balance these different considerations and concerns when it catches wind, either internally through its compliance program or even externally it hears from, for example, a regulator or prosecutor, hey, you have a problem. How does it adhere to the various laws that already that it functions under, both United States laws and EU laws, particularly relating to privacy. And that sort of set me off thinking in general about what does a corporate defense attorney think about this whole world, right? And corporate defense attorneys have to think about a lot of things, but what is a corporate defense attorney thinking about, knowing that the United States has come up with all these programs to encourage insiders and apparently also outsiders, right, to come forward with information. At the same time, what does a prosecutor think, knowing that some of his or her information has come from an insider? And from, let's put it this way, a system, at least more recently, that encourages people to come forward because there are promises of bounties. As Professor Pachella did allude to, we don't always know that the reports are going to be truthful. Or, in fact, it could be that they're truthful, but they reflect something that the speaker doesn't quite realize, that, they think they saw something wrongful and it isn't actually, in fact, wrongful. So with all those different ideas of, how does whistleblowing affect these other actors in the criminal justice and administrative enforcement ecosystem, I'm going to hand it over to Winston Pace, who has a particularly useful perspective because he's been both on the prosecution side, but he's also now on the corporate defense side. Go ahead, Winston.
Thanks, Miriam, and thank you all for joining. So I think it makes sense for me to start from the prosecutor's side, one, just because chronologically, that's how I came to deal with whistleblowers, and I think it perhaps also provides a slightly different perspective as well in terms of I wouldn't say how my views have changed towards them, but at least how you deal with them has certainly changed. And, I think as Mary alluded to in the beginning, when I first became involved with dealing with whistleblowers, it was in the False Claims Act context, because many of the cases that are brought by some of the big U.S. Attorney's Office in the corporate healthcare sector really are based on these key terms of False Claims Act cases brought by whistleblowers who come to the government with information, to share that information to them in exchange, obviously, for getting a percentage of the amount that the government's able to recover from bringing a case or intervening. And typically this happens on the civil side of the U.S. Attorney's Office and DOJ. And that's how it starts. But given, as you can see with a lot of these cases and a lot of I think Mary mentioned $62 billion in recovery, a lot of them, if you'll see, also have criminal components to them that end up having criminal fines associated with them, which tend to be in the hundreds of millions of dollars at times. And so it's become a very important tool for DOJ, looking at False Claims Act cases from the criminal perspective as well. And in fact, one of the biggest cases I worked on when I was in the U.S. Attorney's Office was a healthcare fraud case, which had 9 whistleblowers in that case. And they ran the gamut of, you had whistleblowers who were in the company, so insiders who had come with some information. You had whistleblowers who had indirect information based on individuals that they knew or were friends with within the company and had collected that information. You had whistleblowers who, at least when in government, we used to call them serial whistleblowers, who it was their business model, so to speak, to go in, and these people had nothing to do with the company, but they actually would at times go to the cafeteria of a company and start chatting with employees and record conversations in states, obviously, where you need only one party consent, and that's not a problem. And so they'd have these serial whistleblowers who'd get this information. You obviously had expert whistleblowers as well, and I think it was Mary mentioned in the SEC context, Harry Markopoulos as an example. So you had folks who would provide information based on their expert analysis of how the company is doing and doing well. And then you had competitors, right, who also can be whistleblowers and would bring information. And from the government's perspective, you obviously, if there's fraud, if there's misconduct, if there's wrongdoing, you want to bring a case. So you are motivated by that. And so at first blush, people coming to you with relevant information can be very attractive. But you've got to examine each whistleblower independently, and you have to assess them. You got to assess credibility. You got to assess motivations. Clearly, money is a motivation for everyone. So you take that as a given that clearly they're motivated by money, but you're trying to understand what else, right? What else are they motivated by? Do they have a grudge against the company? If it's a competitor, right? I would say, you're a little skeptical because you want to make sure that this isn't some civil litigation that you're trying to get the government involved in to hurt their competitors. So you'd start off with a slightly skeptical approach, but that doesn't mean you discard what information they're giving or just, take it that it's all false. You got to examine it, but clearly a little bit more skeptically. And the same thing goes for serial whistleblowers, right? But again, it's such a complicated world, and Mary probably has a lot more insight in dealing directly with whistleblowers, that sometimes you've got to assess these things because the first to file, so to speak, in some of these cases may not necessarily be the person with the best information. But the way it works, and I was less involved in this in the civil side, but there was a lot of litigation in this case I did on how to divvy up the pie at the end when you have 9 whistleblowers who are all saying, what stake they should get. And, is it the person who gets the most stake, the one who had the best information but was last to come in the door? Or is it somebody who was first to come in the door and got you started but not perhaps the best information? And those are issues you've got to sometimes get involved with from the government's perspective as well. So, from the healthcare fraud or the FCA key term kind of context, there was one area I dealt with a lot with whistleblowers. Another area obviously became the SEC, given the focus of the work I would do. And it's an SEC program, so I'm with the DOJ, but because there's so much parallel work that we do with the SEC, you would end up meeting these whistleblowers as well. When they came to the SEC, they would, you would talk to them as well, try to assess them in terms of cases you were working on in parallel with the SEC. So again, the same criteria would apply, assessing credibility, trying to understand whether the information they have can be relied on. Is there corroborating information, right? And especially on the criminal side, where you have the burden, which is proof beyond a reasonable doubt, you want to make sure that the information you are relying on is credible. And so always would be assessing credibility of these individuals, trying to understand motivations. You would treat them like cooperating witnesses in some way, and you would try to figure out, what are the holes in their story? Or at least that's how I approached it, when I was talking to them from the criminal side, try to understand that. And, they were incredibly helpful, and you had whistleblowers who helped make cases for us and certainly showed us the right way to go. And we may have been thinking of it from one perspective, but they opened up another avenue often at times and helped us make cases. So they were incredibly valuable. The one thing I think is important to point out is one issue of concern that sometimes I had when whistleblowers would come in was their own exposure. Especially, I'm looking at it from a criminal standpoint, and they would come in clearly initially to the civil authorities, whether it be the SEC, whether it be, our civil division folks, and they would come in and they are much more used to dealing with the whistleblowers. It's kind of, almost a regular occurrence. But when I would come into the picture, I'm more used to, from the criminal side, dealing with cooperators. And cooperators, for the most part, inherently have pled guilty to their crimes before they give you information about the other side. And so having that experience and background in mind, I vividly recall this meeting I was in once, and I'm sitting across the table, and this is the second meeting the whistleblower has come, and so my civil colleagues invited me to come to this meeting. And as I'm listening to the whistleblower explain what happened, I couldn't help but think, you're a co-conspirator at this point in time to all the information you're telling me. You're a co-conspirator, and they're with their lawyer there. So it's not something where you're sitting with someone who's not a lawyer, but their lawyers, and this one in particular, and the most sophisticated firms and who have whistleblowers already know that, they assess that information beforehand. But this lawyer wasn't prepared, and here he was sitting across the federal prosecutor, essentially admitting to crimes in that setting. Without any protection, that even like a proffer agreement or any of that stuff. And so that's something I think that I found concerning, obviously from the whistleblower's perspective, because it wasn't our intention to try and blindside him. But at the same time, I had to point out later on to my civil colleagues, look, based on what this person said, he's got exposure. Like, if you're going to come in from the criminal side, this is going to mean a whole, different ballgame. Like, he's probably going to have to plead guilty. We're not going to sign him up as a cooperator or bring this case without holding him accountable for his own actions. So that was something else that I think is an important aspect to look at from the government side is, does your whistleblower have criminal exposure for either being engaged in or complicit in the actions for a period of time that brings them under the purview of the criminal laws? The other area from a prosecutor you've got to be mindful of is privilege information. And whistleblowers come to you and they, record, they get documents, they do all kinds of collection, obviously to make the best case possible. But you as a prosecutor need to be mindful, am I tainting myself if I just take all of this information without properly examining it? And again, when you deal with law firms who are experts in this and much more sophisticated and are used to, they will do that vetting for you before then, because they don't want to blow up the case by tainting you either. So they will always say, look, there are some things that could be potentially privileged. We'll put this in this bucket, and then we can arrange for a taint team that will review those materials separately away from the prosecution team, who can then assess privilege determinations. eventually we may engage in discussions with the company about understanding the parameters and the contours of what is privileged and not privileged. And so that can be another important factor. And so, mindful of the time, I'll stop there from the prosecution side. There are a few more things I can come back to later, which I think are important to highlight, and switch a little bit, on the defense side. So now that I'm on the defense side, you say, well, are whistleblowers bad people for my clients? And the answer to that is no, because if you are a corporation that wants to conduct itself in as a good corporate citizen, then whistleblowers can and should be part of that process of making sure you detect fraud, making sure you understand what's happening in your company before it blows up or gets bigger and gets out. And so it's not something where all of a sudden you become anti-whistleblowers, or companies should become anti-whistleblowers because they are reporting, so to speak, of wrongdoing. And when you think about it, tips from employees, from a stat that I saw, account for sometimes 50% of the most common way of detecting fraud within the company is really internal employees bringing it to the attention of others. So it is an important aspect, and whistleblowers are important. The other thing from a defense perspective that we advise our clients in terms of whistleblowers, obviously formalizing the process, having the hotline, having policies and procedures in place that obviously protect whistleblowers and make them not fear of retaliation, having anti-retaliation policies, all of those things. But also don't let complaints fester, right? Like, you get a complaint, don't let it fester. Doesn't mean every complaint you get ought to be treated the same way. It depends. You got to look at each one individually and make an assessment. You don't need to retain outside counsel to conduct an internal investigation based on every complaint. I mean, the company would go bankrupt if it did that. So it's not a matter of doing it for everyone, but being judicious in terms of when you do that. Another thing, which is as human nature, you can see we can get very curious and tempted to find out when there's an anonymous tip who it's from. And one thing we always advise is, please don't do that. Don't try to go down that path of trying to figure out who this is. As curious you might be about it, and depending on sometimes the allegations, you are even more curious than you would be. But again, refrain from doing that, and don't discourage ever, any whistleblower from reporting to the government, whether it be the SEC or the DOJ or IRS. It doesn't matter. And whistleblower complaints can come in different manners. Come up to you. It's not always explicit, like saying, "Oh, I found a violation of law," right? Like, no one's going to sometimes always come up and say that explicitly. But things like, there's a problem that could lead to a huge mess. An example of someone bringing that to your attention. Or someone saying, "Oh, that looks like creative accounting," right? It can be another tip, something to look into, and what a whistleblower complaint looks like. Or, I'm concerned about a certain practice. So, as a compliance officer who is, or whoever's listening to this, the hotline, or taking in these whistleblower complaints, you ought to kind of look at them really as what they're trying to say. It's not always going to be explicit, like explicitly said, a rule has been broken. This is a violation of law. It could be something as subtle as, I'm concerned about the way we are doing certain things. It could be like, no one's been listening to me and I've been trying to raise this issue, right? So be mindful for that is what we advise our clients. And obviously stay away from retaliation as well at all costs, despite what we talked about. And we'll talk about some more in terms of what the law is now protecting and not protecting. But as a good corporate citizen, retaliating against an employee doesn't send a good message and a good corporate message regardless. So sometimes it's beyond just, complying with what the law and the books is, or trying to take advantage of changes in laws. It's really about what are you doing to be a better corporate citizen, have a better work environment. And for that purpose, I would say retaliation is not a good idea. So let me stop there, Miriam, and turn it back to you.
Oh, thank you so much. This has been great. And we already have 2 fantastic questions, but I would encourage those of you in the audience who have questions, go ahead and write in your questions in the Q&A, and I'll sort of work those in as I ask my own questions. Winston, you'll be happy. I was so excited when you were talking about the story you told of being a prosecutor. I'm sure your mouth was hanging open when someone walks in and starts saying, oh, I did this crime, and with not even so much as a proffer agreement to protect him. That's always been a great interest to me, which is there's sort of an interesting conundrum there, which is the people who have the most information are probably most likely to be in some way or another, at least under the way we define conspiracy, potentially complicit. And that's always a big hurdle, I would imagine, that people like Mary have to get over when they meet with a whistleblower for the first time. And then, they say, well, I did this, this, and this. And that's probably not the most wonderful conversation to have. I want to ask all of you a question, because I know Jennifer brought it up, and I want all of you, I want to think about COVID. And on one hand, COVID has sent many of us home. And I think that's true also in Europe, right? So we're not in the office. And in some ways, it strikes me that has both good points and bad points for the practice of whistleblowing. The good points might be that you're less worried about retaliation, but the bad points are going to be, number one, you're not overhearing things. So to the extent you do learn things through sort of these sort of informal interactions with others, you're just not there. In terms of also, in terms of reporting, it seems to me there's an additional factor, and this is so I'd like to hear from you guys on this, that could dampen whistleblowing. And it's the following, which is that we have a very tough market. So some companies, a few companies, this has been I wouldn't say a great time, but at least it's not affecting them as much. If you're Amazon, you're going to do your business, you're selling things, et cetera. If you're United or Delta, which I think just reported, I think, at what is effectively a massive loss, you're thinking about furloughs if you haven't announced them already. And which means that those who remain behind and are keeping their jobs are really worried about the market out there. And so even apart from questions of retaliation, the point is, if for some reason your company goes out of business or your unit disappears, you're not going to find another job. Now, that's a lot of stress. And that also, by the way, sets us up also for issues like, when we think about the fraud triangle, right, for rationalizations, right, where people start to tell themselves, well, look, given this market, sure, I'd like to do the right thing. But that's a privilege for people who are living in real condition, in normal conditions. This isn't normal. Or alternatively, by the way, would be some version of rationalization that would look like the following. Well, yeah, we're kind of not following the rules, but that's COVID. Once COVID goes away, we'll go back to normal and we'll get all our numbers back together. We won't do the bad things we've been doing. So I want to throw that out to all of you and see, am I right to be nervous about that? That strikes me as a real problem and one we won't see for many years. Is that something to worry about? And I'll let any of you folks who might have thoughts on that.
To jump in, Miriam, I think it's a concern. It's really not that different than when we had the 2008 economic downturn. We actually see that a lot, and that's a question that every whistleblower faces. In fact, and that's what I spend most of my time talking to whistleblowers about, is not just talking to whistleblowers, but actually literally talking to their spouses, their siblings, and other things, because of the knock-on effects that happen. So I think it is augmented now in the time of COVID, but it's not too dissimilar from what we were seeing in 2008. So for instance, I have a whistleblower client whose brother, he was suing a huge corporation, and his brother was basically a supplier to that corporation. And so his brother's concern wasn't just, the whistleblower's concern wasn't just to his family and the ability for him to work, it's also that his brother would likely be blackballed as well. So I think all of these things kind of can converge and create a really difficult question for whistleblowers. That's frankly what the award seeks to do. The award seeks to be a safety net, a cushion to make someone do what I think many people in their right mind think is not a great career forwarding decision, which is to speak up. So it's there to, I think Winston had said that whistleblowers are all about the money. My view after 23 years is they're very much about wanting it to be corrected, and it's the money that tips them into saying, when they have that conversation with their spouse, I'm about to take this crazy act. they say, I'm going to do all of this, frankly, in the public interest, but what's in it for me? I bear all the costs. I think those are sort of the things that need to be sort of discussed. So I do think we're going to see fewer people speaking up. But that bucks the trend that Jennifer just noted, which is we're seeing, SEC seeing a 35% rise. And I actually think there's other ways to address it. One of the things we've done practically is we do matchmaking with whistleblowers. So what can collective action, when it may be hard for you, sort of all of the Me Too movement, when it may be hard for you as an individual to speak up, if there's someone else in the corporation who shares a different vantage point, who sees the same thing, and you choose to speak up together, that sometimes gets over that hurdle. I feel like we are, and whistleblowers are siloed, and there's frankly a lot of technology right now that should be concerning for employers that seeks to put whistleblowers with concerns together so that they can have that camaraderie to overcome the hurdles of stepping forward. Because if a lot of people are speaking, you can't all of a sudden impugn all of them, right? They're not all crazy. They weren't all bad employees.
So is that like Facebook groups or something? Is that what you mean, or something like that?
Well, yeah, there's some really interesting technology in the UK. There's a group called Beep. They're doing a software that is trying to help empower whistleblowers to solve the problems internally together. But there's a lot of software now that allows, you've got WikiLeaks and all that, but there's a lot of things that allow whistleblowers to anonymously report using some of the similar techniques that and devices that the New York Times does to receive information from anonymous sources. It's no longer the white envelope dropped on your desk. You can interact with these people and have conversations with them. And so I think technology is allowing us to talk to a lot more whistleblowers earlier on who would never have talked to you but for being allowed to speak anonymously. And then you can have that conversation, hopefully gain their trust, and eventually maybe they'll be willing to talk to you.
Jennifer, I know, we were just talking about this. You did allude to the fact that the tips are way up, right, with the SEC. I guess it's tip line. Yes. But the question one might have is, okay, the tips are up, but if the awards stay, right now the ratio between the number of tips, right, the SEC gets something like it's had now since the inception of that program. The SEC's program has brought in over 33,000 tips, right? Number of awards is tiny in comparison to the number of tips. When you look at the whistleblower report every year that the SEC puts out, it's maybe 15 to 20 actual rewards, right, per year. So the question I have for you is, how do we know what's in that volume, right? Is that people with real information, or is that also a lot of folks maybe who are disgruntled, they got fired, they got furloughed, they're unhappy, they got lots of time on their hands? How do we know the difference?
Yeah, that's a great question pertaining to, the information that the SEC has put out. All those same questions came into my mind too. I think I was going to say this too in response to your question before, but I think it is a time where, we've seen a lot of businesses collapse and people get fired already, and, they're angry and they've lost their jobs. And I would not be surprised at all if that's led to an increase in pursuing bounty rewards, actually, at least, because, now they're out of their job. All the research shows that it is so difficult for somebody with a whistleblowing history to get a comparable job in a similar industry. In most cases, they're out of their industry and have to make a living, some other way. So I think in one way, it's kind of ripe for, leading to all this external whistleblowing kind of pursuing of bounties because of sort of the financial destruction of COVID and people being fired and whatnot. But the SEC, for that information they put out, it was quite limited, and there were not details yet about whether any of these, but they have said that they're processing many more bounty claims, compared to a year ago, but we don't know yet if those have resulted in something, that reaches the threshold. Remember, it has to be at least $1 million, right, worth of a sanction. There's different thresholds to get over, and we really don't have the information, I think, quite yet on those that lead to actually being full of merit to lead to bounties. And so I think we'll get that information very soon, especially with, once the annual report to Congress for this year comes out. We'll have to wait a bit for that. But at least within the next year or so, we would know. And that might help to answer some of that question. But yeah, it's just interesting to think how I think that what's happening is that it's a time that's ripe for pushing people who might have stayed within their organization to report to just go external now a little bit more. Because either they've been fired already or situations are just desperate, whatever's going on. Mm-hmm.
So that's sort of interesting to see what the difference will be. One thing that was brought up before I start talking about some of the questions, we have great questions in the Q&A, and I'd encourage all of you who have additional questions, go ahead and add questions to that Q&A. The difference in the culture, and how does the United States, or how do we as Americans, at least I'm going to start now, how do we feel about whistleblowing itself? What's the culture of whistleblowing? And I think in the United States, we have sort of, at least in the last 10 years, certainly there's been an effort to almost cheerlead whistleblowing. There's sort of a view of it as a good thing, right? A happy thing. And as Dr. Langenbrucker was describing, Katya, if you're there, you'd been talking about the idea that culturally whistleblowing wasn't seen as such a good thing in Europe. And I'd love to hear more on that, of what is the cultural view of whistleblowing in Europe. And I don't know if she's still on with us, or she actually,
totally.
There you are.
Yeah.
Okay. Tell me. So I want to hear more, because I think this is interesting. I don't think we have a uniformly positive view of whistleblowing in the United States, in the sense that already, Winston, you were also talking about this too. There, first of all, you do worry about credibility and whether someone has some sort of, we might call it an agenda. But we also, just in the United States, if you think about words, we have the word snitch, right? Snitch is not the greatest implication. That doesn't have the greatest connotation. We also talk about how people feel about their company, this idea of loyalty. Of this idea of being a company man. That was also back in the 1950s, used to hear that comment. And so there is this idea that people who are loyal to their company would never, quote unquote, snitch on it. On the other hand, I think that has changed both in terms of, people don't stay with the same company for 30 years, so that's changed. And then, as I said, the government has done a very good job itself saying, no, you can be a really good person and still, try to internally resolve problems. And then if that doesn't work, externally resolve them. So I'd sort of be interested in what is the view, the cultural reaction to whistleblowing in Europe, and how might that be different from what's going on here?
Yeah, right. And that's a really interesting question. Thank you. And just to give you a couple of examples, so one is the McDonald's France case, had alluded to, where the French courts actually said it's an organized system of snitching basically on people, and discussing the question to what extent there could be rewards and bounties paid out. Again, the French Constitutional Court said in France it's unconstitutional to give someone a financial reward for being a whistleblower. So that is really interesting. We will see how the European different member states will react, and in what ways they will transpose this directive. I'm personally in favor of financial rewards, but I don't know to what extent the Germans will transpose it differently. And to give you one other question, you were talking about financial rewards, both of you, Mary and Winston, and there's interesting research on what people call motivation crowding, right? So that they say, well, if you have a financial reward, and like in the beginning you were the good person who was going to right the wrong and wanted to step forward, and then you were offered a financial reward, suddenly a whole psychological setup changes, and then you feel like, this is something I'm being paid for, and then the whole motivation is kind of off. So there's a couple of interesting stories, and actually even real world studies showing that was one thing in Switzerland, for example, where the question was about a nuclear waste place. And first, people were first asked, and they were all happy, said, yes, whatever, we're going to take the nuclear waste in our neighborhood. And then later on, they were same thing, same study, but offered a financial reward. And then they said, well, really, no, now I feel I'm kind of bought off. So I wanted to kind of give the question back to you in that way, whether you feel that the financial reward is rather something which might tip the balance in the wrong way, or whether, as Mary said, it's going to help anyway.
Mary, you want to take
I would love to jump in. So I have, Katya, I really appreciate that perspective. Having spent 3 years in the United Kingdom, I have my own cultural views on how the United Kingdom, I can tell you how the United Kingdom looks at financial rewards. To a person, for my first 2 years of being there, and even today, if I say in my American voice what I do, that I represent whistleblowers who receive money for bringing information to the United States government, there's sort of this, but we're British. We would have something unseemly about it. That we're British. We do it because it's the right thing to do. You are mercenary Americans, and only mercenary Americans would monetize something like this. So that's been a real hurdle and obstacle I've had to overcome, but I'm very pleased to say, and I've done a ton of debates that have been really fun, where we polled people, had a debate on should British whistleblowers be paid, and overwhelmingly they start out like 70% no. And by the time I've talked to them about what the logic is, and if we don't call them, God forbid, a bounty, which is what we're calling them here in the U.S., they were looked at as pirates. If you instead say it's like unemployment insurance, what it's trying to do is soften the blow. Everyone can recognize that whistleblowers, have an outsized sense, a bit of harm when they blow the whistle. It's not just as to that one employer, but it's obviously future. So I find that really interesting. But to your point of, do the finances cloud the motivation? I would say no. And I think one of the things I wanted to talk about when Winston was talking as well is that this whole notion of why do we expect whistleblowers to come with clean hands? The False Claims Act, which is our original statute, said it takes a rogue to catch a rogue. So there's this notion that, in fact, we pay rewards as long as you're not the architect of the fraud, as long as you didn't create the fraud in order to benefit from it. And if you didn't create, if you didn't create the fraud to benefit from it, you're allowed to receive a reward. It may be a smaller share. So I think it's important. I think culturally, when we pay whistleblowers, we in fact raise their profile. So I would say it's the opposite. At least in the United States, I think the money shows that we value them. But I definitely see a different European perspective that the money taints you. But the problem is, I just think those whistleblowers who want to be pure are going to be pure as casualties on the side of the road, and are going to really. And I guess the most important thing I want to say, Katya, is that 2 whistleblowers that I've worked with recently, who are both British whistleblowers, who were vehemently opposed, are now strong supporters because they've been sidelined and they need that money to sort of help them get on with their lives.
Yeah, Miriam, if I can jump in. So look, I think from a monetary standpoint, clearly, I think from the U.S. perspective, and from the government perspective as well, in particular, I don't think, having a monetary reward is a bad thing or makes someone less reliable, right? I mean, like in some ways, whistleblowers do take a risk when they decide to report against a company or an individual. And so with that risk, if they decide to take one, I think it's perfectly fair. And I think the point I was trying to make earlier was not that all whistleblowers are just, doing it only for the money. I think the point is money is a component that is universally across all whistleblowers. And so because it's a motivation, if you're in the government, as I think Jennifer was alluding to, where you have all of these complaints, you have to assess them. There's got to be a process by which you are assessing the valid versus the not so valid claims. And part of that process, so you can actually, because you're never going to get to all of them, that's the reality. But part of doing that is actually trying to assess motivations, trying to assess credibility. And if you do not consider money as being obviously something that is a factor, then you're kind of not evaluating someone, holistically. So I think it's a factor to evaluate it. I don't think it taints someone, and especially in the U.S. now, where you have different agencies, the government relying on people to come forward and encouraging people to come forward. So it would be strange to then say, oh, now because you're getting the money we are offering you to get, you are somehow tainted, right? So I don't think that's the issue in the United States as much. I just want to touch very quickly, if I can, on a little bit of what was raised by Jennifer and Mary on COVID. And, I think what Jennifer was saying, what at least we've been seeing as well, is a huge increase in whistleblower complaints, during the pandemic. And I think there are reasons for that. One, obviously, the economy is not doing well. And as you saw in 2008 with the financial crisis, anytime the economy does poorly, fraud gets revealed in some way or the other. It's just a natural, cycle of events. So that can lead to additional whistleblowers recognizing it or coming to the attention and doing it. Another reason why you could see an increase in complaints, we're all working home from remotely. We are from home. We're not with the company. There's a bit of detachment from there. Where in the past maybe you would walk over to HR or you'd walk over to the compliance officer and report that. You're a little bit more removed right now, and so you're more likely to be an external whistleblower than when you were part of the company or the culture or community, whatever you want to call it, right? So I think that's another factor as well. You're home. And clearly, look, I think layoffs always will trigger that. And again, I don't say that as a negative thing, as in disgruntled employees. There's some whistleblowers who clearly do it because they love their company and they feel it's going down the wrong path because of leadership, because of individuals, and they want to do it. And there are some whistleblowers who only decide to blow the whistle because now they've been terminated, right? Which is also fine or demoted, right? And again, this is not about judging people's motivations as to why they do it, because everybody has their own financial reasons. You don't want to lose your job by whistleblowing, even though you think something's bad. You may like to try and keep it in house and deal with it. But sometimes you want to go outside, and so. But again, we are seeing increases because of COVID in whistleblowing, and it really, to me, there's time later on, maybe I'll tell an interesting story of, defense lawyers' approaches towards whistleblowers, if that makes sense. I can talk about it a little bit later. I don't want to kind of interrupt the flow, because I think it can be very interesting how that affects a prosecutor, for example, and approaches two defense lawyers have taken in two big cases I worked on. And I think that might be an interesting way to just talk about at least how that plays out sometimes.
So let me incorporate one of the questions. Jennifer, you want to talk for a second?
Yeah, I was just going to add one more thing about just the importance of bounties too, and especially for Dodd-Frank, for example. So let's not also forget that the fate of a whistleblower is usually just such a very devastating one and leads to just so many emotional forms of suffering and depression, anxiety, even suicide sometimes, right? And one of my most recent projects I'm working on too is to note that Dodd-Frank, for example, in the retaliation provisions, does not compensate for any emotional damages, any pain and suffering or any of that. And so it's all the more reason why something like a bounty program is so important to provide, just as Mary said, like that tipping scale to actually come forward. So.
Well, I think it's been written that, being fired or losing your job is essentially, I think, as emotional as a death in one's family. Like, it has the same psychological hit. And I think that, we all know this. People can retaliate against you in very sort of fine-grained ways that would be almost impossible to really prove anything in a court of law, which is why you end up needing some sort of financial compensation, i.e. a bounty. I want to turn it, though, to a different point that this is, so we've started to get some questions. And again, I want to encourage all of you on the line to go ahead and use that Q&A button to add in more questions. So, I had asked you, how does COVID affect whistleblowing? And you could argue there's sort of different effects. One effect is obviously if, as Winston points out, if you're not able to walk over to someone's office and maybe talk it out, you're more likely to, for example, file a whistleblowing claim. You're certainly more likely to do so if you lose your job. But let's talk about a different cultural effect. And this is from Ann Longmore, who submits this question, which is, does the panel think that the highly public treatment of government whistleblowers, will that sort of affect let me just make sure I get this exactly right. Will it be chilling to whistleblowers in the private company context? In other words, if we are not so nice to government employee whistleblowers, and what Anne references, she has this in parenthesis, which is Colonel Inman. This is his report in regard to the president's conversation with Ukraine. Would that chill whistleblowers in the private company context? And let me broaden that, which is, when you blow the whistle, particularly, let's take it out of the False Claims Act for a minute, but you're meeting with the SEC, or you're meeting with the CFTC, or you're meeting with the DOJ. You are meeting with government officials, and that in turn requires a certain amount of trust, right? Trust that these are going to be officials, first of all, that the officials you're working with will still be there. Second of all, that the administration's priorities and sort of public policies won't change dramatically. And by the way, that I think has been borne out with the SEC's program. It hasn't, there are changes, but those changes have not been, massive and dramatic. They're not sort of unexpected. Nothing like crazy has happened from the time of the inception to where we are now. What the question though alludes to is there is some difference because of who our presidential administration, and also because of just right now, it's not so great. Maybe there is some fear about being a political whistleblower. Is that something that impacts corporate whistleblowing, or the fact that we could have a change in administrations? And I guess, Mary, I'll ask you first, because you're on the front lines and you actually speak with potential whistleblowers. Does any of this come up? Or is this sort of, in the corporate whistleblowing world, it's so separate, so different, this is just not an issue?
No, Anne's absolutely right in asking the question, because it's true. There's a spillover effect. People don't distinguish between private, corporate, and public whistleblowers. It's interesting. We have been very public in saying we believe strongly, especially given the number of White House whistleblowers, that we believe they deserve compensation as well. We recently wrote an op-ed about that we don't think there should be a distinction. The reason, of course, cynically why we know there's a distinction is I don't think the United States government wants this powerful tool leveled against them. But to your point, yes, there's a lot of mistrust. But remember, under the Obama administration, there was mistrust in his view of, he was not a big whistleblower advocate, at least in the national security space. So he doesn't have a perfect record, but the Trump administration and Attorney General Barr has been incredibly difficult they basically chill whistleblowers, because the way I point to the Ukraine whistleblower in particular, once the op-ed came out in the New York Times where they said, Ukrainian whistleblower, we have fully corroborated you, we believe you, and you are right. So the only reason you need to know somebody's identity is to check their credibility. He'd been confirmed on multiple levels, I think 7 different witnesses, and yet the administration still pursued their identity as a witch hunt. There's nothing more damning and gagging to whistleblowers or chilling to whistleblowers than seeing the way that there was a relentless pursuit of this person, which could have endangered his life. So there is actually current legislation that is asking to criminalize activity like that if you reveal a whistleblower's identity. So I think this administration has been particularly horrible on whistleblowers. We just talked about Dr. Martin Wright. There's Olivia Troy, who was in the COVID task force for Mike Pence. There's an amazing woman who was in the White House Security Clearance Office, who revealed, the fact that she was being asked to approve clearances for folks like Jared Kushner, who triggered all of the, standard problems. So they have a lot more whistleblowers than we've seen in a long time. So it's a very dire time, and whistleblowers take notice, and they ask us about that. Is it silly for us to file in this administration where they get rid of inspectors general like they're dispensable?
Winston, you've talked about how you advise your clients, and I thought what you said was really interesting. You said, even though you're going to sort of inevitably want to know who wrote this complaint, right? Don't try to figure out their identity, right? So anonymity is obviously, as Mary points out, so important to the whistleblower. Is it harder to get so how does the current administration and whatever's gone on in the political whistleblowing world, how does that affect your clients? In other words, is it harder to get your clients to understand the value of anonymity and why, look, you know what, you guys got to follow this. You can't try to figure out who it is when the government itself seems not to be respecting anonymity? I mean, to the extent we've had instances like that?
Yeah, no, so first, I think I was a little surprised to hear what Mary was saying, but Mary obviously is dealing with the whistleblowers directly, so she has firsthand knowledge. Because I would have thought, from an initial starting standpoint, there are two different things. You've got the government, political / national security whistleblowers, right? And then you have the private whistleblowers, which are the government itself is kind of rewarding you to come forward so it can make its cases. So I would have thought there'd be a kind of a clear distinction between them, but it seems clearly people can have an effect on it can have an effect on you regardless of where you are. So I do see that, but I think to answer your question directly, I think the answer to that, Miriam, is no, because I don't think I'll be making a political statement by saying that most people and companies tend to look at some of the administration's moves as an outlier and something that is just, Trump being Trump or something of that sort, where I don't think it's seeped into corporate consciousness in a way that is like, oh, well, the government's position has changed on this issue, so we are now going to pursue a different path. I think people also understand, and especially, at least certainly our clients do, and I don't mean that just with respect to this administration, but just generally, you can't plan corporate culture by 4-year spans, right? It just doesn't work. And you can't plan it by, I remember telling folks when, at the beginning, the change of the administration, when it went from the Obama to Trump administration, and our clients would be like, well, does this mean now we don't have to build up compliance programs? Is, regulations going to be cut? And I said, no, because look, ultimately, there is an impact from the White House. There is an impact from Main Justice. But ultimately, you have a bunch of prosecutors, and I'll just use DOJ as an example, but this goes towards the SEC, goes to other agencies. And those individuals are in those positions because they've taken them to make cases. They haven't taken those positions to go there and sit down and not pursue corporate wrongdoing, for example, or other wrongdoing. So to me, you're always going to have motivated prosecutors looking to bring cases. And by the time they bring it and make the case, the administration is going to change. And if you are banking on the fact that the administration might be, less lenient or like more lenient towards you, like you can't rely on that. That's just not smart planning at all from a compliance standpoint. So, I don't think that this has affected at least our clients. But, it is concerning. But I also do think people look at it differently, at least from my perspective, where, you had Edward Snowden, for example, and he was a hero to some and a villain to others because it comes, national security people look at it differently. I think corporate wrongdoing, people look at it differently. And putting aside even administration and how this administration has handled some of these things, I think, I don't know if it was Mary or Jennifer who mentioned about even the Obama administration was tough on. People look at it differently when it comes to government, political, national security whistleblowing compared to, corporate whistleblowing.
I think also national security issues is you have certain laws that say you can't reveal, right, classified information.
Yeah, but even talking about non-classified information, right? I mean, that's a crime, right? So putting that aside, even otherwise, people, we talked about the culture of having the word snitch and things of that nature. I think people look at it I would use the word sometimes when it comes to the country, a little bit more betrayal, even more like the snitch, which is even a harsher language. And so I think culturally people are more opposed to that type of whistleblowing than they are to, on the national security side, than they are to obviously corporate whistleblowing.
I would agree. I just would note to folks that both in the UK and the US, there's legislation now to create a public interest defense to the Official Secrets Act in the UK and similar language. I think some of it comes from, I don't know if folks saw the Hollywood movie about Catherine Gunn, the UK whistleblower, national security whistleblower, but a lot of that's being driven by her work.
All right, so I'm now going to add a new question that we have. So I've got one from William Tito Garrett, who's with us, and he runs the FCPA clearinghouse, where we track FCPA enforcement actions and investigations. And he tells us one thing we've seen over the last couple of years is a decreasing number of disclosed FCPA-related investigations by public companies. According to the SEC's annual reports, the FCPA has tended to represent only a small percentage of all whistleblower claims. For everyone else on the call, we're talking about the Foreign Corrupt Practices Act that makes it essentially illegal to bribe a foreign official. All right, so has there been a meaningful change in the types of whistleblower claims since about 2016 that might explain this trend? And do the types of whistleblower claims help drive the enforcement priorities at the SEC? So just to break that out, one question might be, why isn't, and actually I had read this over the weekend, something like only 2% of all bribery cases come from whistleblowers. So why is it that whistleblowing seems not to be driving FCPA or foreign or international bribery cases? And then the other is the SEC's actual enforcement priorities now? So, whistleblowing can be great because you're getting all this information, but does that have, either for good or for bad, an effect on the agency's enforcement priorities? In a way, you could say that good. On the other hand, that could be that it's a distortion, right? There could be more serious crimes out there, and instead the SEC is just going with what comes in through the tip line. So I'll throw that out to the panel, whoever would like to sort of take that first. Mary, go ahead.
Okay, I think it's a great question. I can tell you both anecdotally and I think a little broader than that. Since moving to the United Kingdom, I would say 80% of the whistleblowers that I get coming through my door are folks who, I think because of the prevalence of extractive industries and other international centers in London, that I mostly get FCPA cases and have filed quite a few. So I'm not seeing any drop-off, and I certainly haven't seen any drop-off in prosecutions. I know that's not exactly your question. I actually think that because of the priority that SEC is placing on cryptocurrency, that there have been a lot of ICOs, initial coin offerings, that look like the problems that I've definitely seen their work in bribery that involves crypto. So I would point that out. The other thing that's really positive that I would point out is that the CFTC has finally taken a position that they can also enforce the Foreign Corrupt Practices Act, and they've been very aggressive in talking to firms like myself about the fact that we really want your information. So I think we shouldn't just look at the SEC anymore. I think we need to look at the CFTC as well. They have a very strong enforcement division, and they've been playing catch up to the SEC. They've had a remarkable year and a half. So I do think that, I don't know that whistleblowers drive what the enforcement trends are, but I think certainly if we bring in a bunch of different types of cases, then it will help bring that to their attention, and then could bring it on their radar. But I just think, so much of it is technology decides, right? Crypto is huge, AI is huge at the moment. So I think it's sort of a confluence of both.
Yeah, any of the other panelists who have thoughts on this, I'd be interested to know, because I think that is part of a broader question, which is, to what extent, you can think of this as a fantastic additional tool, or you can ask, does the tool at some point distort the enforcement agency's decisions or even its resources? In other words, does there come a point, and I'd be interested to hear about the European experience with this too, if you're going to start relying on whistleblowing, does that alter not just what the agency decides to pursue, but does that even alter, for example, whether or not the legislature is willing to give more resources to the agency for more enforcement? In other words, you can imagine whistleblowing has a good feedback effect, but you can also imagine it can have a distortionary feedback effect. And I'd be eager to hear from any of the other panelists who might have thoughts on this.
Just a thought kind of related to this in terms of the role of agencies. It made me just think about, for example, take the Sarbanes-Oxley Act, which also has a whistleblower protection program built into it. So it's interesting to think that it was actually OSHA that was put in charge of administering that program, which a lot of people thought was kind of a random decision. And why was it OSHA? Well, because I guess they're the only agency that was dealing with a lot of employee related, of course, safety complaints. And I think, I would stand for many to say that kind of turned out to be just not effective at all, right? I mean, the Sarbanes-Oxley whistleblower program administered by OSHA, and by the way, that's an administrative procedure that the whistleblower has to file a complaint with them, has turned out to be just very problematic and just not helpful for many whistleblowers. And so it seems like there was more foresight put into, the Dodd-Frank Act and the fact that the SEC would administer the program for whistleblowers. And I think we're already seeing notable differences in terms of just maybe getting it to the right agency. There's always there's always going to be a lack of resources though, right? People can only kind of do so much in these government agencies, and which I think is why also the SEC just relies on the tips coming to it so much. So I think it's just interesting to note, which agencies have kind of been assigned by Congress to kind of take things on.
Yeah. If I may, Miriam, as well, I think the reason I think there's a lower number of FCPA whistleblowers that come in. One, if you just look at the jurisdictional reach of, for example, DOJ versus the SEC when it comes to FCPA cases, it's one of those instances where DOJ has a broader reach because it's not contained by the SEC, which can focus on issuers, right? So DOJ can bring cases, for example, against companies who are not issuers, where the SEC can't. So that's kind of one reason. The other reason is also when you think about FCPA cases in general, the core conduct, the discovery of this core kind of conduct and facts are happening in foreign countries. Often, countries far away from here, whether in China, in Africa, Far East. And so when you think about it just culturally, we were talking about earlier, the culture in the United States has now been developed in a way that whistleblowers realize, I see wrongdoing, I can report this, I can get, whether it was, I want to, like you said, whatever the motive, it's much more developed in the US. In a lot of these other countries where sometimes corporate bribery is sometimes a way of doing business, it doesn't trigger someone to think of it in a way of like, there's something wrongdoing, I'm going to go and report it, become a whistleblower. One, they probably have never heard of the SEC to begin with. A lot of the people, sometimes in the countries who are at the core of it and discovering it, they don't know of a whistleblower program. And so I do think these are all factors in why you see a lower number of FCPA cases that are being reported. And I think to Mary's point, where she's seeing an uptick now, and a lot of them, I think as, just corporate bribery, FCPA, in Europe, the UK bribery statute, as these things are becoming global now and the world is focused on bribery in general, I think you are going to see more of those types of cases in uptick. But I think in terms of why you haven't for this long, I think, at least my view is it's for some of those reasons.
Can I add just really quickly, what I have seen is that the good work of folks like Debevoise and Plimpton and Winston, when they go out and require these trainings of their companies, if it's multinationals, a lot of my clients learn about the FCPA from those training sessions and then hold you to account.
All right, let me offer then, I'm going to go to a question from actually one of my students who's here. So this is from Mike Najjar. He says, I'm curious about the effect reporting and media have on corporate whistleblowing. That's particularly relevant given what we heard from Katya about the fact that the EU doesn't like public disclosure. So Mike writes, I kind of view it comparatively of the covering of frivolous lawsuits, which a lot of more left-leaning people thinks have been overblown by corporate media companies that essentially have CEOs and stockholders who have an interest in demonizing lawsuits. It seems like the same thing can be a huge problem with whistleblowers. For example, NBC being owned by GE. One would think that GE has an interest in seeing fewer whistleblowers. Is there a connection between the way corporate media covers these cases versus more independent media? So this is the worry that is media, especially mainstream media, because it's actually owned by big corporations, likely to paint whistleblowers in a negative way. And then I wonder also, I hope we can hear from Katya on this as well, because we already have now, we know overseas you're not even supposed to go to the media. So that itself is a sort of different, it seems like a subcategory of that. But let me throw that out to our panel. Katya, you want to start off?
Yeah, and it's funny that your student asks that, because we have a really current case going on, which is Wirecard. So it's a fintech company, and there was a whistleblower, a couple of whistleblowers actually, but there was also a Financial Times journalist from the UK who uncovered the whole scandal. And so it's precisely the question your student is asking in many ways. I mean, obviously the FT wouldn't count as one of the corporately owned media in the sense I guess he has in mind, but interestingly enough, there were a number of articles in the paper, and still our SEC, so to speak, so our Financial Supervisory Authority, did not react in any way towards looking into the company, but rather they went after the journalists and, were thinking that would have been market manipulation, insider trading and whatnot. So it totally backfired in many ways. I mean, now obviously everybody's really unhappy. Nobody took up that, but it's really interesting to what extent they're and I'd be interested to hear your views about that. To what extent would the SEC look into media coverage and would take that as something almost as if like an external whistleblower had been stepping forward, right?
And in fact, I've been to various, and I'd be interested in the other panelists, but I've been to various conferences where usually there's someone from the SEC who says, oh, we take seriously everything we read in the paper, or something generally like that. And I can think of, I think what would probably be the Walmart case, which involved allegations of bribery in Mexico. That was a big New York Times expose that I think did lead to a lot of activity. So, I think we certainly do see activity after it shows up in the newspaper. I seem to recall even when I was a prosecutor, it was not uncommon that if you saw something in the newspaper, someone might say something, oh, what are we looking at? We should look at that. So I don't think we look negatively. Now, the question that was raised was actually, do we have some worry that somehow media doesn't uncover these things because media itself is owned by companies? I imagine the NBCs of the world would say, no, we're very, very inclined to make these things known. The one thing I will say, if I'm remembering correctly, except one of the most famous insider trading cases that's decided by the Supreme Court is a case where someone tries to take the information initially to, I think it's the Wall Street Journal, and it doesn't get published initially. I think, Winston, you're nodding, so I assume you know that too. And so sometimes I think what it is the more established newspaper article or journalist may be less willing to engage that risk, whereas the more startup kind of indie journalists might be more willing to take that risk. And that might have some interesting parallels with what we're talking about with regard to whistleblowing.
Yeah, no, just, in terms of what Katya was saying, in terms of when I was a prosecutor and working with agents all the time, newspaper articles were an important source of starting investigations. You would read something that caught your attention, you'd talk to the agents, you would see if there was a valid basis, obviously, to open it, and then you would open investigations based on that. 60 Minutes was another thing. You watch 60 Minutes and you hear something and you'd be like, oh, let me check if somebody's looking into that issue, and you would base it. So from a DOJ government perspective, and I think the same goes for the SEC, media reports, have been, they're a starting point. It's not you have the case because the media has written an article, but they certainly are a starting point to opening investigations because there's just so many avenues of how you get information and start an investigation. Obviously, today the focus has been on whistleblowers, but they are one piece of the puzzle, right? There are different ways. You have victims who come in and report. You have obviously, you can open it to media. Sometimes you have individuals come in and turn themselves in and report it too. So you have all different ways in which you can start a case. But to answer your question, Katya, I think, the media was certainly an important factor when I was in DOJ.
Miriam, can I wanted to jump onto that conversation. I think there's an interesting example from the UK, a whistleblower by the name of Michael Woodford. He's the first non-Asian CEO of Olympus Corporation. And he actually came to know about the fraud because a small investigative news outlet called Newstapa, I think it's Newstapa, basically started to say there's problems. We're seeing, strange accounts and money moving within Olympus. And there was even connections to the mafia. And he learned all of that just from investigative news outlets, smaller investigative news outlets. I did want to go back to the original question, though, because it touches on our cultural issue. How does media portray whistleblowers, and what impact does that have on corporate whistleblowers? My clients tend to come to me because whistleblowers, at least in the United States, are lionized in movies. So you've got everything from Aaron Brockovich, Serpico, Mr. Smith Goes to Washington, The Insider, The Whistleblower, Silkwood, there's just, you name it, we have whistleblower movies. And I think that's helpful to at least show the important role that they play. But I would say that besides the Hollywood movies, the 60 Minutes, a lot, even GE-owned news outlets, like the ratings that they get from the David versus Goliath stories that make up 60 Minutes. Everyone loves a David versus Goliath story. Everyone loves a scandal. So I think we will still be seen in those programs, but I agree, some of our best sources now are more independent media. My client is Tyler Schultz, who is the Theranos whistleblower, and I think he's a case in point of a darling of the media. He has his own podcast. Of course, there was the HBO series, The Inventor. There's now going to be a Hollywood film. There have been multiple podcasts, including his own. So that's an example of sort of traditional media covering this sort of thing. And I actually think in that space, because to your earlier point, Miriam, I actually think in the startup space, it's a lot easier to be a whistleblower, because those in Silicon Valley and elsewhere, I think there's just more of a concept of reinventing yourself every day, right? There's not the same bit of loyalty. So there's a lot of tech whistleblowers I've seen, like Dr. Jacques Paulson, who exposed Google for human rights issues, and Erica Chung and Tyler Schultz and many more. I just think they've been able to continue to work in the business, and that notoriety doesn't seem to have hurt them.
If you have a freewheeling atmosphere, there's the benefits of the freewheeling, and then that means that everyone's a mercenary. That means everyone can report, right? Sorry.
I was going to say, as Mary was describing that, from the government and prosecutor standpoint, we would cringe when, the whistleblower or someone who potentially could be a witness down the road would be out there in the public making statements or having podcasts or, and this is public now, but, Grigory Roshchenkov, who was the Russian doping scandal whistleblower, kind of come to our office back in the day. He gave a huge article to the New York Times, and they published a front page article with his picture on it, and we can understand now why that was done. But whenever you have someone like that who's a whistleblower who's going out, because you're thinking from a prosecutor standpoint, this guy's going to take the stand one day potentially, and he's going to be testified, and all the statements that they are making in public are going to be used to cross-examine them. And when you're talking freely, whether it's to reporters, whether it's on a podcast, you say things not with the same care you would in a courtroom. And so, just kind of as Mary was talking about that made me realize back in the day when you'd cringe. Now as a defense lawyer, probably you're like, wow, that's amazing and great. And you want to mine all of that information if that you ever have to cross-examine that person.
So I think, let me ask the final question to get you guys going. So when I graduated law school, which will now be, I think next year would be 25 years, I think, right? I don't think there existed such a thing as a whistleblowing practice, right? I don't think within the law firms. I mean, there were definitely law firms that focused on securities fraud, brought big class actions, but that didn't happen. Of course, there also, although there was such a thing as compliance in particular industries, there wasn't anything close to what we call the compliance industry today, right? So that too has changed. And I know, Jennifer, you've written about that. And then 3, when I think back to the law firm with which I spent my 2L summer and then, worked in the litigation department for 2 years after I did my clerkship, we didn't have anything close to, at that time, big law firms didn't have what you would call the white collar investigations department, right? There might be one partner, if that. And Katya, you might have insights on this as well in Europe. And so one question is, to what extent, where is this industry, right? We have an industry of lawyers now, in-house who thinks about compliance, outside who represents defendants and thinks about, everything from, sort of, they get, as Winston's talked to us about, how he thinks about telling clients to think about how to think about whistleblowers, how to think about the government, how to think about both the difference between a prosecutor and a regulator. And then, of course, we have people like Mary, who play a huge role, right? Because she is essentially both, it sounds like you're everything from psychologist to counselor to investigator, right? You are the person who's doing a lot of legwork. So where's this industry going? And what do we make of the fact that we now have a very, we have a very mature industry, which on one hand is a great thing for the people, the participants on this phone call who are looking for interesting career options. But also, is that good? Is it bad? What does this tell us about I'd like to hear more on the industry. Where do you guys see the industry going 5 to 10 years from now? How will it change?
Well, for me, to give you the outsider's perspective, it's the same. So we're seeing compliance departments, which have been wrapped up after the financial crisis, especially. And it's the same for all those, intermediaries of various ways, consultants, lawyers, auditors. And I mean, I'm torn. It's definitely something which is more alien to a European culture. On the other hand, I personally am pretty much for it because it does help to break through a lot of groupthink mechanisms we're seeing in corporations and on boards. And so the more you're forced to discuss, certain situations or certain decisions you're taking, it will usually help. Right? It will usually help. And I mean, saying that, I do see that, of course, it's an industry. Of course, it costs a lot of money. Of course, there's transaction costs. But all in all, I'm personally more positive about it and like that influx of probably US culture into Europe. Last not least, because Europe, at least continental Europe, more than the UK. Mary is going to tell us more about the UK probably, but continental Europe is still a pretty, I don't know how to say that, like a corporations-driven culture, right? So where that groupthink I was alluding to is still really powerful. And so all the forces which come somehow from the sidelines will typically rather help, at least for now.
Thank you.
Yeah, and I would just add to that. I think it's here to stay, and I think it's simply a reaction of the legal practice catching up with developments in the law. Because if you think about it over time, I think there were definitely whistleblower lawyers and practices, but they were all surrounding the False Claims Act, right? Because that's a statute that's been around since Civil War times. And you need legal representation to get through it. Dodd-Frank is pretty new, right? Newish, 10 years old now. And requires, especially if a whistleblower is going to handle it anonymously, requires counsel to be involved, to lead them through the whole bounty process. So I think it's simply a response of just legal practitioners and the industry to just what the law is today. And I think we'll only see an increase in this in more, maybe just more job opportunities for students thinking about it too, into the future, just like compliance. Mm-hmm.
And Mary and Winston, I'd love to hear.
Sure. So in terms of where I take a very international view on where I think whistleblowing industry and just the accompanying industries are going in compliance, we have seen it's not just the United States that has reward programs. Now Canada has a comparable program for the Ontario Securities Commission. And then they put their own culturally appropriate permutations. They've got a $5 million cap on the program. We're seeing the expansion of these programs, of these concepts internationally. So Canada also has an offshore tax improvement program. So if you're avoiding taxes and you're Canadian and overseas, then you can, if you're showing that information, you can receive a reward. Believe it or not, Africa, as Katja mentioned, in Europe, we have in competitions the markets authorities. They pay whistleblowers even in Europe, because how else do you bust a cartel and cartel busting type activity? So the biggest exciting territory for us at the moment is South Korea. South Korea has a 50-year-old tax reward program that far outdates ours. They have a new program as well that deals with anti-corruption, but it's very much part of their initiative to attract more business and be more transparent. So I think the future is in other countries looking and each learning from each other. So I'm not saying that the American model is perfect. In fact, while I think we're really great at empowering whistleblowers, to Katja's point, I think Jennifer mentioned this, I think we're really bad at protecting them. It's very siloed, as we mentioned, Sarbanes-Oxley, but if you don't fall into one of these windows, as Jennifer said, we need an umbrella piece of legislation. EU is getting towards that. The UK has something called the Public Interest Disclosure Act that does that. So we as Americans need to prove, and we need to learn more in the retaliation space, but I think that we're seeing more collaboration. The last thing I'd like to say about the industry is that I'm really happy to see the rise of the compliance, and now they're calling themselves the compliance and ethics industry. And I think they're getting more. It used to be, I think their voices were never recognized much in the boards, and they were sort of seen as a cost center and very, not particularly helpful. And we've had some amazing research coming out of George Washington University and the University of Utah that is supporting something that I've said forever, which is that whistleblowers are actually good for business. They actually have a positive effect on your ROI. So my hope is that people will start to see, as Winston mentioned, and Jennifer as well, that whistleblowers can be the CEO's best friend. They are, to use business speak, they are forward indicators of risk. So if we can change that, and we're starting to see more embracing of that they're sort of first responders, canaries in the coal mine, and I think there will hopefully be fewer cases for me. And I would be happy for that to be, because 85% of the whistleblowers, according to the SEC, report internally first. They don't want to ruin their careers. They want the company to correct it. And so the more those companies are listening, the more that we have these amazing compliance and ethics personnel being trained and active and empowered, the less they're going to come to me. And I think that's a great result.
Well, I don't think, Mary, you have to worry about your job going away anytime soon. But Winston, why don't you take us to the end?
Yeah, no, look, I think I pretty much agree with what's been said. I just don't see this as something going away anytime soon. I agree that what you're going to see, just like I talked earlier about FCPA whistleblowing now expanding globally, and I think that point was made as well. I do see this becoming more global in scope and not just more of a US thing or a UK thing to the extent that it is. But, I do think it's going to be more global. And the one thing to watch for is there always sometimes can be, a rollback sometimes just with almost everything else we deal with when it comes to laws or regulations or, programs like the whistleblower program, where and you see that with these recent amendments, right? If there is abuse, if they feel there are kind of a lot of false claims coming in, and not from the false claims actually with the SEC or other agencies, you could see kind of a tightening of what is considered reliable or acceptable, or the intake rules may change. So you can always see things like that. But I agree. I don't think the program in itself is going away anytime soon. And I think companies as well have adjusted to the fact that this is what life is now, and they have to deal with it, and have tried to make the best out of it and look at it from a positive standpoint as much as possible. And look, it's not always, because if somebody goes to the media and are just out to try and destroy the company, so to speak, because they have a grudge. It's hard sometimes for the company to look at that as well. That's a positive development, right? So I think it just depends on circumstances, but for the most part, I agree. This isn't going away anytime soon.
And so with that said, we're at the 2:45 mark. So I am going to, first of all, thank our audience who provided great questions. But I want to thank most of all our 4 panelists who have given us a fantastic overview of everything that's been going on in whistleblowing. This was really great, and I think it will give us all great food for thought. And of course, if any of you in the audience have follow-up questions, I'm sure our panelists are happy to answer some over the email. And so this is going to conclude our program at Brooklyn Law School. For those of you who decide to watch this will be posted on our website. And again, I hope all of you in this lovely time of COVID are taking care of yourselves. So take care of yourself, be safe, and don't forget to say good things to a whistleblower when you see one. Okay, thank you all, and I'm going to sign us all off. And before I forget, let me again thank Elizabeth Alper and Mike Licari, who helped us with the technical portions of this program. Thanks so much, guys. Okay, that's it. Thank you all.
Thank you, Miriam. That was great.
Thank you.